this meeting of the Judiciary, Finance, and Civil Law Committee to order. We are meeting remotely under House Rule 10.01. We will start with the attendance. Anna, please go ahead with the roll.
Chair Becker-Finn.
Present.
Representative Moeller.
Present.
Representative Scott.
Present.
Representative Feist. Representative Frazier.
Present.
Representative Grossell, excused. Representative Herr.
Present.
Representative Hollins. Representative Johnson.
Present.
Representative Liebling.
Present.
Representative Long.
Present.
Representative Mortensen.
Present.
Representative Novotny.
Present.
Representative Barr.
Present.
Representative Robbins.
Present.
Representative Bang.
Here, present.
Representative Zhang.
Present.
And let's see, Representative Feist.
Present. Sorry about that.
Oh, that's okay. And Representative Hollins.
Present.
Perfect.
All right, quorum is present. Representative Feist, do I have a motion to approve the minutes for February 26, 2021?
Yes, so moved, Madam Chair.
All right, thank you, Representative Feist. Any discussion to the minutes? All right, seeing none, all those in favor, please say aye.
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 Opposed? All right, the minutes of February 26, 2021 are approved. Members, we have a very full schedule today. We're going to try to get through as much as we can so that we don't have quite as much work to do when we come back in the evening. So as always, we'll ask members to stay focused and do our best to stay on target for what we need to get done today. The first bill we have up today, we'll get right to it, is House File 450, which is a Representative Richardson bill. Welcome to the committee, Representative Chair Richardson. I will move your bill. I move that House File 450 be recommended to be laid over for possible inclusion in our Judiciary Finance Omnibus Bill. We now have the bill before us, and Representative Richardson, I believe we have, you have an author's amendment. If you could tell us real quickly what that author's amendment is, and then I will move your amendment.
Thank you, Madam Chair. The author's amendment is merely a technical correction with a typographical error.
Got it. All right. Well, I move the A1 amendment to House File 450, put the bill in the shape that the author desires. Any discussion to the amendment? All those in favor, please say aye.
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 Opposed? All right. The A1 amendment is adopted. Representative Richardson, please tell us about your bill as amended.
Thank you, Madam Chair. House File 450 provides a right to counsel for public housing tenants unable to afford counsel in breach of lease cases. The bill is designed to level the playing field between public housing tenants and public housing authorities, which are represented by publicly funded attorneys. The bill is narrowly tailored and limited to breach of lease cases and excludes cases related to non-payment of rent. Safe, affordable, and accessible housing is essential for family stability, social and economic well-being, and mental and physical health. The impacts of displacing families from their homes has long-lasting negative effects on mental, physical health, family unity, and economic well-being. When we look at mothers who experience eviction, they have significantly higher rates of depression, parenting stress, and material hardship. Children and families that experience eviction are more likely to be placed in out-of-home care, which is associated with adverse childhood experiences, poor short and long-term physical and mental health outcomes, and there are also costly impacts of this to address, including homeless shelters, emergency room costs, school funding, and foster care costs. Extensive research shows that tenants with legal representation are much more likely to avoid an eviction judgment and keep possession of their homes than unrepresented tenants. And Hennepin County data collected between 2016 and 2018 showed how the extent of representation, be it full, limited, or none, influenced tenant outcomes in cases. In all dimensions of the studies, tenants with full or limited representation fared better than unrepresented tenants. A few highlights from the study. Tenants with full representation won 21% of their cases. Those with limited representation won 24% of their cases. Unrepresented tenants won only 11% of cases. 52% of fully represented tenants remained in their home, compared with 48% of tenants with limited representation and only 31% of unrepresented tenants. 78% of fully represented tenants left courts without an eviction filing on their record, while this was only true for 17% of tenants with limited representation and only 6% of those who were unrepresented. Also, notably, the study showed that represented tenants are 4 times less likely to enter homeless shelters. Appointed counsel in public housing cases can be an effective means to stabilize families and communities and reduce burdens on publicly funded programs. We have received questions from counties about the fiscal note, and we are continuing to work with stakeholders to find a funding solution that works for all involved while leveling the playing field between the public housing tenants and publicly funded attorneys. And today I have with me Attorney Larry McDonough and Noah McCord, who will testify on the bill.
All right, thank you very much, Chair Richardson. We will go to the testifiers. First on the list, I have Larry McDonough. Please introduce yourself for the record and then go ahead with your testimony.
Thank you, Madam Chair. My name is Larry McDonough. I'm Senior Minnesota Counsel with the Lawyers Committee for Civil Rights Under Law. I've represented about 10,000 tenants and landlords over around 40 years of practice as an attorney, and I've also been a landlord myself over the years off and on. I just want to say just 2 or 3 very short things about this. First of all, we patterned this bill off of many of the existing court-appointed attorney statutes in Minnesota. So the structure of this is very similar to what we found in commitment, guardianship, quarantine, parentage, and juvenile proceedings. Many jurisdictions around the country are looking at right to counsel, and we see this in cities and states around the country. We chose to focus on public housing tenants for 2 reasons. One, they really are the most vulnerable tenants. The families are very low income, elderly, people with disabilities, and they have a subsidy in their housing so that if they lose, they're not only vulnerable physically because of their vulnerable status, but they're also vulnerable because of their incomes. Their incomes are very low, and these subsidies really make the difference between being housed and not being housed. And secondly, we chose this because it's a very complicated area of landlord-tenant law. I mean, I've done this a long time, and these are the most complicated cases because it's a mix of federal public housing law and administrative law and constitutional law on the federal end. And then on the state end, you also have the law of contracts and the law of real estate. And so all those things mix together to make it a very complicated area where people pro se don't do well on their own. And lastly, in terms of the number of cases, this is a fairly small swath of cases, and we chose that specifically to keep the funding amount down. When we looked at cases from 2016, the 60 publicly available public housing eviction cases we could find, 50 were from the Twin Cities metropolitan area, Duluth, Rochester, and St. Cloud. And so when you look through greater Minnesota and smaller communities, many had none of these cases or maybe one. And so that was kind of the thought process we looked at as kind of having a smaller kind of financial impact than if we were swinging much broader than this. So with that, I will stop talking and take any questions you might have. Thank you.
All right, thank you, Mr. McDonough. We will go to the second testifier before we get to any questions. The second testifier I have on the list is Noah McCourt. Noah, please introduce yourself for the record and go ahead with your testimony.
Thank you, Chair Becker Finn and members of the committee for hearing me out this morning. As you mentioned, my name is Noah McCourt, and I'm a disability advocate here in the state of Minnesota. And I wanted to take a minute to just discuss the way that this would impact people with disabilities. And it personally brings to mind 2 particular stories that I've dealt with in the past few years in regards to housing and evictions and public housing. And the first comes out of Richfield, where an individual had a hoarding issue, and the previous management company had been very supportive of the way that of some of his needs. And when that switched out to a management company that did not have necessarily the experience to support him in that way, he really ended up on the chopping block and ended up being evicted. And I sat in that courtroom as I was watching the eviction proceeding, and could very much tell that the heart was there in the legal matter, but the really the knowledge base was not. And while it felt to some like justice had been served, to me it really felt like railroading. Railroading an individual who didn't have the income level to fight back against an eviction, or B, really even the knowledge base or skills to do it. And so it really just kind of was very, it just kind of ate at me, I guess. And I found it to be very unjust and problematic. And another case in South Minneapolis recently, where an individual simply missed a court date and was evicted. And, you know, having ADHD, people always look at that as, oh, someone's just hyper, but it's so much more than that. It comes with a pattern of disorganization and a lot of other aspects that really make it difficult for people to focus and keep up with the sort of rigorous process and work that has to go into fighting an eviction and preserving housing. People with disabilities do have a right to accommodation both under the Fair Housing Act and the ADA, as well as Section 504 of the Rehabilitation Act and other areas of law. And so there are other areas of law that could protect them in ways, in addition to the ways that Mr. McDonough had mentioned. But we continue to see a need for accommodation and for the courts to really understand disability and the way that it impacts both areas of civil and criminal law. And so we really support this bill, and we encourage the passage of House File 450. And we really see it as being in the interest of justice. Thank you for your time today, and please pass House File 450.
Thank you very much for your testimony, Mr. McCourt. I don't have any other testifiers on the list. Members, any discussion to the bill or questions for our testifiers? Representative Johnson.
Chair Becker-Finn, Representative Richardson, I understand the meanings, the intent behind this bill. I just do have some questions though. One of my concerns is the cost. As we start going down this, there's going to be some funding that's going to be required. I'm just wondering if you can explain if this is going to be on the backs of the counties or the municipality that might own the facility. Is it going to be on the backs of the owners of the properties paying for this? It's going to be back of the county, the state. I'm just wondering what your plans is for funding this program.
I'm guessing that was a question for Representative Richardson. Representative Richardson.
Thank you, Madam Chair. Representative Johnson, we are currently working with stakeholders. We're talking not only with the courts, but with the counties as well to find a pathway forward in terms of thinking through funding. As Mr. McDonough stated, we're talking about the scope of this is fairly small. We're talking about 60 cases from sort of that have been pulled from historical records. And I also think it's really important to highlight that there are also savings to be had as well as we look at the increased costs that counties are absorbing in terms of out-of-home placements for foster care, also looking at costs of shelter as well. So it's a nuanced conversation, but we're working directly with stakeholders around that. And I think Mr. McDonough may have something to add as well if Madam Chair would indulge.
Yep, Mr. McDonough.
Thank you, Madam Chair and Representatives Johnson and Richardson. Yeah, what I would add is that what we estimate about $1,000 per case on the high end. And so we're looking at about $60,000 statewide for all the cases combined. In some counties, no cases. And
Rachel,
and some more. Thank you.
Yep, sorry about that. Representative Johnson, I will remind members too that we're laying this over, so there's certainly time for conversations to continue about this. Any follow-up, Representative Johnson?
Yeah, I just my concern is with the current federal rules on HUD and stuff. A lot of this is taken care of. Regarding some of the evictions and the process that has to go through. So it's not, I'm not sure if this is actually needed, but I understand it. I guess we need to make sure that as we go through this, that we're not doubling up some of the federal and state requirements, making it to a position where the people are going to be, the owners of the property are going to look at a lot harder and maybe not actually rent to some of these facilities if they have to go through these new rules that we're putting into place for public housing.
Any response, Chair Richardson?
You know, I think I would share a couple of things. I mean, the way that this bill has been drafted, it's focused specifically on, as Mr. McDonough said, the most vulnerable within public housing. And so with that, it's really important to recognize that not only are we talking about sort of an uneven playing field, just in general, we're talking about an uneven playing field with some of the most vulnerable Minnesotans, people with disabilities, seniors as well, and extremely low income families. And right now, when there is a public housing case that is going to housing court, those individuals don't have the ability to have a right to representation. And it's also, I think, really important to look at the data that has been pulled as well to show that with representation, we see better outcomes for families. And we also see reduced costs on our counties and our states as well. And I think Mr. McDonough has something to add as well, Madam Chair.
Mr. McDonough.
Thank you, Madam Chair and Representatives Johnson Richardson. Just two things to add. We are talking about public housing authorities, and so these are governmental agencies. So we're not talking about private landlords like the landlord I used to be. And also that the public housing authorities in these types of cases have their own attorneys. And so it really is about evening the playing field so that there are attorneys on both sides. Thank you.
All right, Representative Scott.
Thank you, Madam Chair. Just real quickly, I'm just wondering, I know, I haven't been in eviction court for quite a while, thank the Lord, with a tenant, but I'm just wondering, we go in there and just represent ourselves in eviction court. And granted, we know the business, whatever. It was a learning process for us too, though, by the way. But I'm wondering if these people have to have an attorney come alongside them. Are there other people that are trained to help represent them in just this eviction process? Because to me, it doesn't, no offense to any of the attorneys on the call, but sometimes you're just, it's not needed. There could be other advocates in place of an attorney in cases like this. And I'm wondering if you might find more people that are available to help in those situations than trying to find attorneys, which are kind of in short supply in this sort of realm and dealing with these lower income situations.
Well, I will note it's only attorneys can represent other people in court. So Representative Richardson, I don't know if you have more to add to that.
I think I would just, add briefly that, again, we're talking about a specific cohort of public housing tenants. And within the public housing authorities, there are going to be publicly funded attorneys that are provided for those cases. And so again, we're just talking about ensuring that within that public housing realm, that individuals would have the ability to have access to representation that is government funded, because the public housing authorities are publicly funded as well.
Quick follow-up, Mr. McDonough, and then we're going to lay this bill over. So I'm sure that Chair Richardson will be open to further discussing the details to figure out how to get this done this year. Response, Mr. McDonough.
Thank you, Madam Chair and Representative Scott and Richardson. Part of the reason why the public housing authorities do assign attorneys to these cases is because they are complicated. And from when I was a landlord, a non-payment of rent case is not as complicated in private housing. But the types of cases we're looking at here with the mix of federal law and state law really does make them more complicated. And having an attorney for the tenant to balance off the attorney for the housing authority just adds the due process that I think we all like to see in the court system. Thank you.
All right. Thank you, Mr. McDonough. And with that, I will renew my motion that House File 450 as amended be laid over for possible inclusion in the omnibus bill. Thank you, Chair Richardson and your testifiers for being here today. The bill is laid over. Thank you very much.
Thank you, Madam Chair.
All right, we'll get to the next bill on the agenda today. The next bill we have up is House File 1060, Representative Agbaje. Representative Agbaje, I believe this is this maybe the first time you've been in front of our committee? I will move your bill. I will move that House File 1060 be recommended to be placed on the general register. The bill is before us. I believe there's also an author's amendment. Representative Agbaje, if you could explain your amendment briefly, and then we'll get to the vote.
Yes, thank you, Madam Chair. So the A3 amendment is a result of conversations with advocacy groups and landlord groups that have had some questions about the original language in the bill. So the first change is on page 4, and that removes the reference to the Safe at Home program, as advocates are working on a different avenue to better address the current challenges within that program. On page 7, there are changes to the language concerning the enforcement of settlement agreements. Rather than proposing further court proceedings as was in the original bill language, this amendment provides that a court may seek additional hearing regarding the alleged violation of a settlement when the proper affidavit has been filed and served by the party seeking redress from the alleged violation of the settlement agreement. The amendment also changes the original bill language on page 9 that removed the ability of a plaintiff to pay a bond and for the court to issue a writ of recovery in certain types of appeal cases. This amendment would allow the plaintiff to pay a bond and the court to issue a writ of recovery if they won the case based on a violation of 504B.171. And so this amended language then provides no need to repeal Minnesota Statute 504B.371 subdivision 7, which has been removed in this. And so that is the A3 amendment.
All right, I will move the A3 amendment. Any discussion to the amendment? All those in favor of the A3 amendment, please say aye.
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 Opposed? All right, the amendment is adopted. Representative Agbaje, please tell us about your bill as amended.
Great, thank you so much, Madam Chair and members of the committee. So now that the bill is in the form desired, we'll briefly introduce it before turning to my two testifiers who will discuss the bill's impact and walk through the changes that House File 1060 proposes to the eviction process. So when a landlord seeks to evict a tenant, the process in Minnesota is one of the fastest in the country. Taking as little as 8 days after filing, in just 1 week, a whole family's life can be turned upside down. An eviction makes it harder to find new housing, more likely that a family will end up in worse housing, or possibly with no options at all. Eviction comes down hardest on Minnesota's low-income families across the state. And as an attorney myself who has volunteered at the Hennepin County Housing Court Project for more than 3 years, I've seen firsthand how fearful tenants are of losing their homes. I frequently counsel people who fall behind on rent and who just need time to apply for emergency assistance. If this bill becomes law, tenants and landlords would have that time built in to find a meaningful solution that may not necessarily need the court as often. So the updated processes in this bill create a more just system for all parties that ensures due process and helps them understand their rights. And as you'll hear from Mr. Elwood and Ms. Dobson, this bill is vital to update our laws to meet the changing realities of our state. And so at this time, I'll turn to Mr. Elwood to continue with the presentation.
Great. Thank you, Representative Agbaje. Mr. Elwood, please introduce yourself for the record and then proceed with your testimony.
Thank you, Madam Chair and members. Ron Elwood with Legal Aid. I want to thank Representative Agbaje for bringing the bill forward. And so, you know, the court eviction process in Minnesota is essentially the same in 2021 as it was when Minnesota became a state in 1858. But the consequences of eviction, not just for the person losing their home, but also for children and their children and generations to come, are very, very different in 2021 than they were in 1858. Eviction is a life-altering event, and the evidence is clear that evictions fall disproportionately on BIPOC communities, perpetuating poverty, housing instability, and racial injustice. Evictions, of course, are civil cases, but they are treated judicially different from all other civil cases. There is more time to adjudicate a dispute about whether someone's tree encroaches upon their neighbor's property than a person gets to defend against the loss of their home. In our experience, in 70% of cases that Legal Aid handles, our clients have a valid and persuasive legal defense. The impact of this bill will be to ensure that adequate due process when a family is at risk of homelessness and the cascading parade of adverse consequences that occur from eviction. In short, the process just does not currently provide adequate time to seek legal help and identify and prepare a defense or find financial resources. We understand, however, that the timeline should not stretch out interminably. Rather, we seek a modest extension of time for the purposes articulated. But I want to be crystal clear. This bill in no way impugns landlords or implies in any way that many landlords don't work hard with their tenants to avoid eviction. And it does not dismiss concerns we've heard in our discussions with the Minnesota Multi-Housing Association. The amendment made today, in fact, reflects some of those concerns. And in a similar vein, the bill recognizes the need to preserve the expedited eviction procedure in current law and maintains that provision intact. Nothing changes a landlord's right to commence an expedited eviction when dangerous or illegal behavior is endangering other tenants or landlord's property. We respect the views of the Multi-Housing Association, are always open to continuing dialogue with them and working with them to seek common ground. Thank you very much, Madam Chair and members.
Right, thank you for your testimony. Next on the list, I have Joey Dobson. Ms. Dobson, if you could introduce yourself for the record and go ahead with your testimony.
Good morning, Chair Becker-Finn and committee members. Thank you. My name is Joey Dobson, housing policy attorney with Legal Aid. Thanks for the opportunity to join you all again today. Just very briefly, I'll highlight a few of the key due process provisions of House File 1060 and the way that it would give reasonable time and opportunity for all parties to be heard and provide meaningful information to the court. First, the bill requires landlords to share information they already have readily accessible on hand, the reason they're filing the case, the basic document related to the tenancy, the lease, and any notice to vacate at the time that they file the case. Second, current law presumes that an eviction trial will happen the very first time the parties enter the courtroom. It ties the hands of the court and only allows judges to continue that trial for 6 calendar days. This bill provides that trials would happen no sooner than 10 days after the first court appearance. It gives the parties and the court the time that they need to gather the facts, evidence, and the time for the parties to make their case. It would also change current practices of requiring tenants to pay money into court in order to even have a trial. Other key due process provisions of this bill include giving both the landlord and the tenant a judicial remedy to enforce a settlement agreement, providing the same right to a renter to appeal a decision as any other defendant in a civil case has, and ensuring that tenant screening agencies don't report expunged cases and that what they're reporting is accurate. So again, just very briefly, House File 1060 would simply put Minnesota's eviction court process in a place of a little more fairness, provide key due process where it's desperately needed. Thank you again, Madam Chair, for the opportunity to testify, and I'm happy to answer any questions.
All right, thank you for your testimony. We do have 2 additional testifiers who had signed up. We will go to Chris Calla. If you could introduce yourself for the record and please go ahead with your testimony.
Good morning. Thank you, Madam Chair. My name is Christopher Calla. I'm an attorney with the law firm of Hanbury and Turner, located in Minneapolis. My law firm represents owners and managers of rental housing. We routinely appear in state court, the Court of Appeals, and federal court on those types of matters. A large part of my practice is representing landlords in housing court throughout the state of Minnesota. My testimony today on House File 1060 is based on my experience litigating these issues both at the trial level and at the Court of Appeals. I'd like to first start with the amendment regarding the appeal statute 504B.371. The proposed change is needed that evictions under 171 are excluded from the ability of a landlord to bond around when the landlord prevails at trial, but the tenant wants to appeal. And just for reference, 504B.171 includes the 4 categories of eviction for breach of lease regarding illegal guns, stolen property, prostitution, and drugs. But the vast majority of evictions in Minnesota are non-payment. They're not breach of lease. The problem with this amendment is that it doesn't address a lot of other breach of lease cases which would escape the ability of a landlord to bond around. And let me frame that. If a landlord were to bring an eviction under a list of cases I'm about to give you, and the landlord prevails, this amendment would allow the tenant to stay in possession of the apartment during the entirety of the appeal. Currently, the landlord has the ability to what we call bond around by simply paying into court the amount of money that the tenant might have to pay extra during the time of their displacement. Here are a list of cases that I've actually litigated, breach cases, that wouldn't be included under 504B.171. So imagine a landlord has this situation, they win, and the tenant stays there for 9 more months during the appeal. Arson, assault, rape, sexual harassment, sexual assault, homicide, child pornography, criminal damage to property, reckless discharge of a weapon, underage drinking, leaving a window open and causing pipes to freeze and burst, causing damage to apartments below, smoking in a non-smoking building, unauthorized dogs defecating in the hallways and not cleaning up, terroristic threats, unauthorized occupants who don't pass security screening, defeating security measures in a building, kidnapping, racial epithets. None of those evictions, if a landlord wins, would the tenant have to leave, even if the landlord is willing to bond around during the pendency of the appeal. Statistically, since the year 2000, there have been about a dozen cases where a tenant, where possession is the issue on appeal, where the tenant lost at trial, but was reversed and was awarded possession. 2 of those cases were commercial. The other 10 or so residential. 2, the tenant was actually displaced. The other cases, the tenant stayed in the property during the appeal and was not displaced. This amendment to 504B.371 is addressing a microcosm of the cases that are actually occurring, but would cause massive disruption for landlords. Imagine you are a landlord of housing in a campus area, and your lease expires August 31. You have new tenants, new students moving in. The old tenants don't vacate. You bring a holdover eviction. During
Mr. Call, I'll just remind you that we've got one other testifier, so you got about 30 seconds to wrap up.
Okay, so I think I made my point on 503.371. As regards to Section 6, Ms. Dobson talked about that trials happen on the first day of the first appearance. That rarely happens. In my experience as an attorney, I've never seen a situation where a legitimate defense is offered to the judge and a case hasn't been continued for trial. And lastly, I want to touch on Section 1, and that is the delimiting of the evictions from a summary proceeding. What this would basically do is create a situation where any dispute between a landlord and a tenant would be resolved in housing court. If a tenant is also a caretaker, you would have employment issues. It completely delimits the problem, delimits the cases here. I would ask the court, I would ask the committee to not pass 1060. Thank you.
All right, thank you for your testimony. The last testifier signed up today is Bradley Shapey. If you could introduce yourself for the record and go ahead with your testimony, go ahead.
Good morning, Chair. My name, excuse me, my name is Bradley Shapey. I am also a real estate attorney. I have a component of my practice does include landlord-tenant law. Most of my practice is compliance, but I have for many years been involved in landlord-tenant cases across multiple counties in Minnesota. So first off, I respect all of you and your public servants trying to figure out where the reasonable regulation is. And there is a role that Minnesota should play in 504B in protecting tenants. And so I think that's what we're trying to have a discussion about. And so I applaud your continued interest here. And I'm not going to get into the weeds here, but just to offer a little bit of perspective. First of all, I think it's important to, before any vote on this issue, is to understand the full timeline from start to finish. Basically, as if you had a chart mapping out one to the next, from the 14-day notice to the additional time for the summons to the amount of time it takes to schedule the county to schedule that hearing, since we're doing away with that time frame, to the minimum 10-day trial, to I know it's now been amended on the settlement breach, and also on, in some cases, which is not impacted here, the additional time for storage, which is up to 28 days. And put that in perspective with what our municipalities are in good faith also doing, such as Minneapolis and St. Paul, which are effectively capping security deposits. So what the net effect here is that you have a transfer of costs shift onto landlords, and many times due to smart public policy, some of these costs cannot be borne by lower socioeconomic tenants. So effectively now, in the current status, yes, you can proceed with standard evictions, usually in about a month time frame. And this roughly on average would probably add about another month that of additional costs above and beyond that 1 month security deposit that currently works now. So that's the main point I wanted to talk about is that I think it's important for the decision makers to understand the time frame, the costs, and also understand how does the process work today and how will it work in the future, in addition to potential costs on our judicial system of more trials and more time. So with that, let's see, I think I had one more comment. I'm happy to be a resource for future questions in the future, and I thank you for your time.
Thank you. And I think Representative Agbaje, did you have a follow-up to some of the testimony?
Just briefly, I'd just like to note that, the types of cases that this new process is trying to address are, the very typical cases that come into the court system. 504B.171 does allow for that carve out for very serious criminal cases. But some of the other types of situations listed by some of the testifiers really are just kind of usually at the allegation level in an eviction type case. And so what we want to be able to have with House File 1060 is ensuring that both landlords and tenants understand their rights, have access to due process, and aren't advantaged in one way or the other, especially when it comes to the appeals process of one party being able to pay while another is not. And so that's what I'd like to respond with that, and happy to take any questions.
All right, thank you. Any questions from members or discussion? Vice Chair Moeller.
Thank you, Madam Chair. And I have a question about the appeals. I know a testifier had some concern about the amendment, about the delay while the appeal is taking place. And my question is for legal aid. I'm just curious how many of these tenants actually end up appealing these cases. My guess is that it's not many, but I would appreciate that information. Thanks.
Ms. Dobson or Mr. Elwood?
Thank you, Madam Chair and Representative Mueller for the question. I don't have an exact number, but based on my experience, and I also have litigated many eviction cases, my guess is that it would be fewer than a dozen residential eviction appeals cases each year. And I would just note that there are a number of burdens to a tenant appealing an eviction case, including the administrative burden, and getting it all right. As we heard about our previous bill, very few tenants are represented by counsel. And those that are, often by folks like myself at Legal Aid. You know, first, we have rules under our professional rules of conduct that we would need to bring a meritorious argument to the Court of Appeals. And then the Court of Appeals, of course, would need to accept that appeal through their procedural guidelines. So those are the comments I would make. Thank you.
Any follow-up, Vice Chair Moeller?
No, thank you.
All right, Representative Johnson.
Chair Becker-Finn, Representative Agbaje. Agbaje, sorry, I apologize for that. I'm just wondering if you could explain to me what were the circumstances on that 8-day eviction? I've done eviction notices, and I've had the point where from the initial notice, 8 months later, 9 months later, having to finally physically remove somebody from a rental unit, whether it was an apartment, a townhome, or actually a physical home. The only time that I've had shorter ones that lasted a month and a half before we physically removed somebody because of severe safety issues for other tenants. One involved having a meth lab in the facility. The other one was due to some other criminal activity going on that the person had to be evicted. So I'm just wondering if you could explain what the eviction that only took 8 days was and what the circumstances were, so we have an idea of how, because generally when you go to court, you give the eviction notice, you get a 10-day notice for court. It happens usually within 10 days, usually it's a little longer than that. And then the person is given 30 days to remove themselves before the next process starts. And it can go through 3 or 4, and it's usually 8 to 9 months before the law enforcement has to physically remove somebody from a facility. So if you could explain the 8-day circumstance, I would love to understand that, because like I said, this is the second time I've heard of that particular case, but I've never been informed what it was and what the reasons were. Thank you.
Representative Agbaje.
Yes, thank you, Madam Chair and Representative Johnson. So when you read the statute as it's currently written, what it does is a summons is filed and then submitted to the defendant, which is the tenant. They then need to appear in court within 7 days. That on that 7th day, that is actually the trial day. In practicality, there are a number of judges that will then extend that out, provide a continuance. But if you have a judge that does not, and if you are a tenant who doesn't have an attorney, doesn't really quite know what's going on, a judge could then order that you have been evicted on that day. And then a writ would need to go out. And usually the writ is about 24 hours and you could be evicted. So the issue is not so much that, you know, we're seeing a large number of 8-day evictions, but that we want to ensure that tenants and landlords both understand what the process is, and making sure that we're not, if we go by the letter of the law as it's currently written, that we are not in a position that we can put people out of their homes after 8 days. And I believe Ms. Dobson has some more to add.
Yep, Ms. Dobson.
Thank you, Madam Chair and members. I would just add to what Representative Agbaje mentioned, that there are, in Hennepin County Housing Court alone, each year there are thousands or hundreds, if not over 1,000 cases that are defaults, where a testifier in the previous bill mentioned the many hurdles to certain individuals who are most likely to face eviction in coming to court. And so any case where the tenant is unable to make it to that first court appearance, what typically happens is in that case, the court does issue a writ of recovery. So I would just note that we see a number of defaults. And then also a vast majority of eviction cases do settle, in part because of the court's interest in judicial efficiency and reaching amicable agreements. But that quick timeline leads to a majority of cases settling at that very first appearance. So then that case would then be disposed of. It would be done at that very first court appearance.
Quick follow-up, Representative Johnson.
Chair Becker-Finn, members, and the current process is that, and the testifier stated that it's usually worked out. It might be that first court appearance, the judge awards the eviction, but if they don't move out in those 30 days, they give them time to find another facility, they can come back to court and explain what happened and why they didn't move. And a lot of times things are worked out in those 30 days, so the eviction process stops. By moving this forward, I think you're going to make it less likely that people are going to want to rent. In fact, I had a gentleman in my district contact me this week. He was talking about renting out his basement because it's a fully furnished, his mother-in-law's apartment type deal. But after he read the laws and just happened to check what's going on here in this committee, he has decided not to do that anymore. And so we've losing rental space, and it would have been a great workforce housing unit in my district, which we were in desperately need of. So I have problems with this, changing it. I think the system we have actually works. It works well. The judges and the landlords know that sometimes people have circumstances beyond their control. And a lot of times you just get a hold of the landlord, especially in privately owned and not multi-housing. The landlords will work with you because it costs them money to go to the courts. They usually lose 1, 2, 3 months worth of rent if they don't work with them. So I think this is setting it up to have less rental units, and I can't support this bill. Thank you.
All right, we will go to Representative Long and then we'll go to the vote. Representative Long.
Thank you, Madam Chair. I have 2 questions for Ms. Dobson. The first is that it feels like from some of the testifiers we've heard that there's a bit of an effort to have it both ways on the timeline, that folks are saying, well, there's never really a trial with the first court appearance, but there's also opposition to extending the timeline, the 10 days. And I don't quite know how to square those two. It seems like if folks are okay with not having a trial in the first court appearance and having some timeline like the 10 days makes a lot of sense. And then we also, I think, heard some numbers on the timeline that this would extend trials for, or that it would be 2 months, and that doesn't comport with what I'm reading. And I was wondering if Ms. Dobson could respond to those.
Yep, Ms. Dobson.
Thank you, Madam Chair and Representative Long, for that question. I agree with your interpretation of the timeline. Currently, as Representative Agbaje has described, the court is only allowed to stay the trial for 6 days, 6 calendar days. This bill simply says that they need to schedule it out at least 10 days. The difference between 6 days and 10 days is a big deal when you're talking about this short of a timeline. And I would just note that there is no 30-day, after a determination is made, there is no 30-day kind of extension. Right now, in fact, the court only has the ability to stay a writ once they've made a determination against a tenant. The court at maximum can only stay a writ of recovery for up to 7 days, and that's only upon a showing of hardship by the tenant. So the sheriff can only come out as long as 7 days after that court hearing. Thank you.
All right, Representative Long.
Thank you, Madam Chair. Last question. So Representative Johnson also said that these matters are usually worked out between the landlord and a tenant. That wasn't my experience when I was practicing in landlord-tenant cases. And I'm curious, Ms. Dobson, what your experience has been if these are typically cases that are able to be worked out or worked out, as Representative Johnson said, even after the court has issued its determination.
Ms. Dobson.
Yes, thanks, Madam Chair and Representative Long. I will say that while it is true that a vast majority of eviction cases in general are settled, that is earlier on in the case. Often it's in both parties' interest to avoid a trial and to reach some other resolution, whether that's a payment plan or an agreement to move out. Once there has been a writ of recovery issued, at that point, the family is looking at a 24-hour timeline of a sheriff coming to remove them from the property. So at that time, I think it is rare for cases to amicably resolve at that point in time. Thank you.
All right, real quick, Representative Scott, we've got many other bills to get to today. So Representative Scott.
Thank you, Madam Chair. Just real quickly, Representative Long, have you owned rental property before?
Representative Long.
Yes, I have.
Okay. And do you try to work it out?
Representative
Sorry,
Scott.
Madam Chair, do you usually try to work out situations like this with your tenant because you don't want them to leave? You want them to have housing?
I don't believe that this is a trial of Representative Long's landlord doings, but Representative Long, if you choose to answer that question.
Sure, I've never been in a situation where I've had to evict a tenant.
Well, that's good for you.
Representative Scott.
I'm sorry, Madam Chair.
I know the back and forth is fun, but that's not how committee works. So
yeah, I know. I'm sorry. I won't go on with any more questioning. Thank you, Madam Chair.
All right, and Representative Johnson, you've already had a couple bites at the apple. So if you can keep it under 30 seconds, and then we're going to move to the vote.
Chair Becker-Finn, thank you. I just wanted to clarify something. After the court notice or the court hearing, the sheriff's office delivers the final paperwork. And on that paperwork is that generally it's a 30-day notice to remove themselves. If they don't, after 30 days, a second set of papers are served, given another court date. And I believe it happens 3 times before law enforcement finally gets the order to physically remove somebody. It does not happen on the first case.
All right, thank you for that, Representative Johnson. With that, there are no additional amendments to the bill. I will renew my motion that House File 1060 as amended be placed on the general register. The clerk will take the roll.
Chair Becker-Finn.
Aye.
Representative Moeller.
Aye.
Representative Scott.
No.
Representative Feist.
Aye.
Representative Frazier.
Aye.
Representative Grossell excused. Representative Hurt.
Aye.
Representative Hollins.
Aye.
Representative Johnson.
No.
Representative Liebling.
Aye.
Representative Long.
Aye.
Representative Mortensen.
No.
Representative Novotny.
No.
Representative Farr.
No.
Representative Robbins.
No.
Representative Vang.
Aye.
And Representative Zhang.
Aye.
There are 10 ayes and 6 nays.
All right, with 10 ayes and 6 nays, the motion prevails. House File 1060 as amended is on its way to the general register. With that, members, we'll move on to the next bill. Representative Herr, we have House File 398. This is your bill. Would you like to move it to be recommended to the general register?
Yes, Madam Chair, I move that House File 398 be recommended to pass and place in the general registry.
All right, and I do not have any amendments for this one. So Representative Herr, please go ahead and tell us about your bill.
Thank you, Madam Chair and committee members for hearing House File 398. Before I speak to the bills today, and I have a number of them, I think the rest of them are all mine, I just want to say a few general words around housing. I want to first acknowledge that most tenants and most landlords are good people. That sometimes there are disputes between good people and sometimes there are bad actors on both sides. We need to remember that landlords write the leases. The law, in addition to outlining the parameters for tenants and landlords, must also include specific rights and protections for tenants. That helps level the playing field. But the truth of the matter is that Minnesota's tenant landlord law have not received serious revisions for decades. I have four bills today that help bring some of these needed balance. As we hear these bills, I hope we remember that we are all talking about not just apartment units or rental units. We are talking about people's homes. And as a renter, you should have the same rights as a homeowner to making that house your home. And so with that, House File 398 is a bill that addresses 3 issues pertaining to heat and repairs. Minnesota renters deserve to live in a home that is warm. If they don't control the thermostat, their home should be heated to 68 degrees from October 1st to April 30th, wherever they live in the state. This bill proposes a statewide heat code. Additionally, the bill proposes that more housing issues be considered emergency repair needs. While Homeline's testifiers will go through the details, I don't think that it is too much to ask that a broken refrigerator or non-working elevator rises to the level of emergency repairs. Finally, it currently costs tenants roughly $300 to file a court case concerning emergency repairs. That is simply too costly a burden to place on households who are already paying too much of their income into their monthly rents. They're living paycheck to paycheck. Reducing this fee to $70 brings this filing in line with conciliation or small claims court. With that, Madam Chair, I do have testifiers here today to speak on behalf of these bills. And the first is Samuel Spade from Homeline. He is the housing attorney and research director.
All right, thank you, Representative Herr. Mr. Spade, please introduce yourself for the record and go ahead with your testimony.
Thank you, Madam Chair and members of the committee. My name is Samuel Spade. I'm an attorney at Homeline and Homeline's research director. Homeline itself is a statewide nonprofit organization. We do a few things, but primarily we provide free, confidential, legal, and practical advice through our tenant hotline to residential tenants in Minnesota. Since our founding in 1992, we've advised over 250,000 renter households throughout the state, and we're currently averaging over 1,000 calls each month. For House File 398, I'm going to start with heat. We receive hundreds of calls each year about a lack of heat or inadequate heating. We've taken 105 this year since January 1st. And the loss of heat or inadequate heat can be a serious health issue, especially for children and seniors. There are protections in state law already against a complete loss of heat, but there is currently no state law that specifies any type of minimum heating requirement in residential rental properties. This has resulted in cities passing their own regulations. And so while there are many cities that have some type of minimum requirement, it can vary a lot from city to city. There are also many cities that have no requirement or that only require the heating system to be capable of maintaining a certain temperature, but don't actually require the landlord to do that. And this inconsistency creates confusion and in some cases results in renters living without adequate heat. In a state like Minnesota, after several weeks of sub-zero temperature, it should be inconceivable that some of our neighbors who rent their homes might experience this inadequate heat. As Representative Herr said, this bill remedies the issue by requiring landlords to maintain a minimum temperature of 68 degrees Fahrenheit from October 1st through April 30th if the tenant does not control the heat, and only if the tenant does not control the heat, and makes this requirement part of the covenants of habitability. This would track with what many Minnesota cities already require, and is something that all Minnesotans should be able to count on in their homes. The next issue I want to cover is emergency repairs. We regularly talk with tenants facing emergency repair issues, which make their homes nearly unlivable. These emergencies range from loss of water, heat, or electricity, to loss of plumbing, threats of condemnation, and more. Minnesota law, though, currently has a very short list of repair issues that explicitly qualify as an emergency. There is a catch-all for the loss of other essential services, which is very helpful, but years of working with tenants has taught us that it is not always sufficient and leaves a lot to chance, and more importantly, argument with the landlord. Being able to designate a repair as an emergency is also very important to tenants. Tenants can still force landlords who are being uncooperative to follow the law and fix non-emergency repairs, but it takes much longer. For example, if a tenant goes through a rent escrow court case, that could take 1 to 2 months. However, a tenant can normally get an emergency repair issue fixed in a week or less, sometimes in as little as a day or two. So that ability to designate, again, a repair as an emergency is very important for a tenant. And this bill would expand the explicitly listed emergencies to include no working refrigerator, no working air conditioner, if one was included in the lease, non-working elevators, serious infestations, the loss of any conditions, services, or facilities that pose a serious and negative impact on the tenant's health or safety, and condemnation orders. Finally, this bill addresses an issue with outdated court filing fees. Currently, a tenant can file a court case called a rent escrow, which is a court case that can be used for non-emergency repairs, for approximately $70. However, if the tenant has a serious emergency, such as a complete lack of heat, or they've been illegally locked out of their homes, the filing fee is approximately $300. While some low-income tenants can apply to get these fees waived, some cannot, or they may have difficulty navigating the court process to do so. And as a result, this $300 filing fee can serve as a serious barrier to filing these types of cases. This bill would also reduce the cost of filing the lockout petition or the emergency tenant remedies action to the cost of filing a rent escrow action, making them more accessible for tenants facing these issues, which again are among the most serious issues a tenant can face. Thank you for your time, and I would be happy to answer any questions.
Yep, thank you for your testimony. We do have a couple other testifiers. Next up I have is Mr. Lockett. If you could introduce yourself for the record and go ahead with your testimony. May have to unmute yourself.
Sorry, I'm sorry about that. Good morning. Good morning.
Go ahead.
Good morning, Chairman Becker Finn and the members of the committee. My name is Mathis Lockett, and I'm currently a resident in Brooklyn Center, Minnesota. I have come to talk to you about the heat and repair issues that I've had with my landlord for the past 2 years. My spouse and I rent a single family home, which is not up to code whatsoever. Within that time, the landlord had to replace the water heater, furnace, tree removal, and the list goes on and on. For example, last year our furnace went out, and when the heat went out, it was so cold that my spouse and I had to stay at a hotel until it was fixed. This was something that my landlord did not reimburse us for. The proposal of a Minnesota statewide heat code is 68 degrees Fahrenheit. What helped us in the house, but many of our rooms do not even supply that heat, proper temperature whatsoever. Additionally, the furnace issue was not ever fully fixed. To this day, the entire house is not able to maintain heat. We have space heaters, which cost us more money, and the concern of a fire hazard as well. Now, the legislation's goal is to include a broken refrigerator and infestations as emergency repairs that will have helped us as well. When our refrigerator broke, we notified the landlord and it was not fixed within 24 hours. This made also that our food went bad and we was never reimbursed for that either. It took the landlord about a week to get a new refrigerator. This has obviously led to more personal expenses and a major inconvenience. Now, regarding infestations, currently right now, we do have a bee's hive nest that's hibernating in our basement. Now, infestations are always bad, but bees can be painfully harmful. Finally, an emergency tenant's remedies action can protect renters to ensure that emergency repairs are done in the right way. This is important because our landlord has a history of not completing the repairs in the right timely manner. They do not have a professional to even come out to ensure that these issues are even taken care of, nor have they had any of their agents follow COVID precautions, like prime example, wearing a mask. I know this because in the past, we have gotten random people that they know to come up here and fix things that a professional needs to fix. This has resulted in repairs not being done correctly, leaving you with lasting issues. For example, You basically have the furnace, the pipes, the damages of bringing in a refrigerator, with my experience. If we are able to file an emergency tenants remedy action under these extended emergency repairs, a judge could ensure that those repairs can happen quickly and in a timely manner and safely. Obviously, I also support the legislation's goal to reduce the court fees for filing an emergency tenants remedy action. The current cost is around $300. And currently right now, with everything that's going on, it's very steep for our household income right now. Thank you so much for letting you share my story today, Chairman Becker-Finn, and the members of the committee.
Thank you very much for your testimony. We have one more testifier on the list today, Liana Stefaniak. I'm sorry if I mispronounced your name. Please introduce yourself for the record and go ahead with your testimony.
Thank you, Madam Chair and members of the committee. My name is Liana Stefaniak, and I work with At Home Apartments, which is a property management company located here in the Twin Cities. Before I begin with my comments, I do want to thank Representative Herr for her acknowledgement that most residents and most landlords are good people and behave and act in the way that they should to provide good, stable housing. And I'm also sympathetic to the testimony of Mr. Lockett. My comments today, though, are on a broader scale, as some of the testimony has been very specific. With regards to the minimum heating requirement, while we live in Minnesota, it is a cold climate. This proposal doesn't recognize that we do have different climates and different climate zones within our state. Our building codes do recognize that. We have a zoning code at 6A and zoning code 6.7. You know, what's going on in northern Minnesota doesn't always translate to what's happening in southern Minnesota. So I'm not arguing that all residents should have good, adequate heat. They should. But we need to recognize that there's a difference between the different regions of our state, and a minimum heating code might not properly address that. Local control in those areas is a good thing, as Mr. Spade pointed out, that many cities have provided minimum heating codes based off of their locality or location within the state, and that's the proper way to address heating issues. The other thing I'd like to point out is within the Minneapolis and St. Paul, largely some of our buildings are older and are done on boiler heat systems. And while that can be finicky at times, one of the things that does disrupt adequate heat and minimum heat to units is tenant behavior. If you are in if you're in an older property that is boiler based and one tenant doesn't seem to care and wants to open their window because they're smoking in their unit or doing something else, that throws off the heating for the rest of the building. And yet this becomes the landlord's issue, as if the landlord's violating the minimum heat requirements with no acknowledgement that tenant action could be taking place here. So I would like to just, leave my comments there on that issue, but ask Representative Herr to maybe look at her language and recognize the different climate zones for our state. On the expansion of the ETRA, I do think there is, a list, and there's good, the list that is currently provided in the statute does adequately outline the issues for which a tenant can provide or file for an Emergency Tenant Remedies Act, but the expansion of it down to appliances and other issues could be problematic. As Mr. Spade pointed out, duration is an issue. And it's also an issue on the side of the landlord. In the event, for instance, a air conditioning unit does break down in the summer, it's a seasonal activity. And oftentimes suppliers, hardware stores, what have you, have limited supply based on what they need for that time of year. A landlord in good faith can be doing everything they could to go get said air conditioner, but supply is limited. And suddenly now we're violating the ETRA without bad intention. The other issue that I'd like to raise is I understand a non-working elevator in a building is problematic. It's just as problematic for the landlord, but to render this an issue for the landlord to say that they're violating some sort of habitability and therefore the tenant has an ETRA action against them, when again, duration is a problem. If it's a building that has an older elevator and we need to wait for supplies and we're doing everything we can, there should be some acknowledgement of that. So I'm not arguing the fact that tenants should have the right when they are, as Mr. Lockett described, when there are serious issues going on in his household. We absolutely agree with that, but there needs to be an understanding that duration, and supply does impact the landlord, and it's not because of bad intentions that they're not trying to fix the issues in the tenants unit. Thank you.
Great. Thank you for your testimony. I will say, as the family member of someone who relies on a wheelchair to get around, that you know, the loss of an elevator is quite is a bigger problem for someone who relies on that elevator than it is for someone who doesn't. So I do think that's important. Further, I just want to make sure, members, that we're careful, you know, about the language that we're using as far as people being good or bad. I think we need to be careful about that, as far as, you know, people's actions may be problematic, but that doesn't mean that we have bad people and good people. It just means that some people's actions may need to be corrected. Representative Herr, any response to the testimony?
Thank you, Madam Chair. I know you're short on time, so I'll just go really quickly that I understand that the issue of the different heating zones has been brought up a number of times. And to be honest, 68 degrees is 68 degrees, regardless of which zone you live in. And that this bill becomes much more important, knowing that in some parts of the state it gets much colder, and to request a minimum of 68 is really a minimum of 68. So I just wanted to touch on that really quickly. Also around older properties and boiler systems, in that you know, people pay for being able to live in a place that is habitable, and that these are issues that you know, we have asked for landlords to provide solutions, in which we have not received any solutions. And so to continually point out that, you know, there's just these buildings that they can't control, but nobody's offering any solutions of how to do that, becomes really impossible for us to look for solutions that can be helpful in this situation. And it's not from a lack of asking. I've asked many people who've come either to testify, or the organizations that are do not like this part of the bill, to provide a solution, which none have provided any. So I can't make changes if no solutions are offered. And then you've already addressed the elevator, the other emergency repairs. So I'll just leave it at that, Madam Chair, and I'll take any questions from the committee.
Thank you, Representative Herr. We'll move on to member discussion. Representative Johnson.
Chair Becker-Finn, Representative Herr. I understand the reasons for this bill. I do have some concerns. Looking at your list on lines 3.20 to 3.29, I'm looking at a hot water heater, loss of heat, loss of electricity, which generally has no control by the landlord if the power goes out. Or if the water main breaks somewhere and they have to shut the system down, the landlord has no control over that. If the water line that breaks that goes into the home or into the facility, it could take days to line up all the people to come and fix it. They have to do the locates for all the other things in the ground before they can even start digging. That could take 2 or 3 days just lining things up to get it fixed. I know personally myself, I had a refrigerator go out in my home. The day it went out, we went down to the, I can't remember, I'm not gonna name the name of the store down in the metro, got a new one. They had to order it. It took a week to get here. They delivered it. Unfortunately, when they opened it up, it was damaged. It took 2 weeks. I had to go without a refrigerator, and we ordered it the very day our refrigerator went out. In my father-in-law's business, we had a furnace go out. We called a repair person. He came out, got it running for 1 hour, and it went out again. He ended up having to order a new circuit board, which took 3 weeks to get here. A lot of times, landlords, the vast majority of them, do their best to make things right. So I have some issues with this bill, just because of the way everything's on it. There's so many things in here is beyond the landlord's control, that the landlord is being forced to comply with, that can hurt him financially and make him so he might not want to even rent anymore. That I have a lot of concerns. And I understand Mr. Lockett's testimony, but if I heard it correctly, he was renting from a place that has not been approved or up to standards by the city code. I would suggest you contact the city where he lives to make sure that those are brought up to code and that he actually has a license, has the proper paperwork in place and everything is right in order to rent out that property. I think that's where that needs to start instead of something like this bill. Thank you.
All right, thank you. Next on the list is Representative Robbins.
Thank you, Madam Chair, and thank you, Representative Herr, for bringing this bill. You know, I'm torn on it, honestly. So I just had a couple questions. First, on the 68-degree heat thing, I've not been a landlord, so I'm asking just from my perspective as a homeowner. In my home, we have several rooms that are further from the furnace that just don't, I mean, they're cold year long or hot, really hot in the summer, really colder in the winter. And the furnace works fine. We've had it looked into, like, just because of how the home is laid out and because the repair guy says of how far the rooms are, the only real fix is we would need to have separate heating zones for each area if it would work. And like, I don't know, does the home uniformly have to be 68 degrees or just, and how do you measure 36 inches from the wall and from the floor and all that? Like where does the temperature gauge have to register that? And also, like as a homeowner, my family were on this plan where to save money and to be environmentally conscious, we are part of like this thing where in high peak demand, the energy companies overrides our own temperature settings. So it gets way hotter at certain parts of the day and way colder at certain points, depending on demand all over, you know, the region. And so are those cost-saving devices not able to be used if it overrides, you know, would change the fluctuation of 68 degrees? And then secondly, just, you know, reflecting on that.
Actually, Representative Robbins, I think that was already a couple questions. So I'm going to let Representative Herr respond to those, and then you can ask the last one. So Representative Herr.
Thank you, Chair Becker-Finn, and thank you, Representative Robbins, for the question. It's hard for me to answer your first question because I don't know the temperature variation between one of your rooms to the other one of your rooms. Is it 1 degree? Is it 10 degrees? You know, that would be really difficult for me to answer. And so I think that that creates a situation in which then I would have to guess in everybody's situation if they can feel the difference between 2 degrees versus 10 degrees. And so I would prefer maybe not to be stuck in a situation trying to answer a question that there is no answer to. The second thing is that your question around, I can't remember the second question. It was around
how you measure it.
Representative Robbins.
I'm sorry, Madam Chair. How you measure it in that thing the bill talks about, 36 degrees from or 36 inches from a wall, from the floor. Like physically, how is that measured? How will a landlord do that?
Representative Herr. Question B. I thought that was part of your first question, asking about the different variation in temperature from each room. I thought there was a second question after that.
Yes, ma'am. I'm sorry, Madam Chair.
Representative Robbins.
Yes, so on lines 2.4 and 5, it says it must be measured at a distance of 36 inches above the floor, not closer than 36 inches from any wall. Like I don't physically understand that.
Representative Herr.
Madam Chair, sorry, Madam Chair.
Well, it looks like Mr. Lockett may be able to weigh in here. So
yes, I'll have him weigh in, but I do just want to say really quickly that as somebody who owns a home, that where your thermos is placed actually impacts how your house warms up. So like if I have a thermostat sitting in a certain spot where the sun is hitting it all the time, it's going to change what the reading in that room, and it's not going to measure the temperature accurately. So there are specific requirements to help with, for people to understand that thermostat placement does matter. But I will let Mr. Spade answer the question.
It actually, Mr. Lockett first.
Lockett, my apologies.
You'll have to unmute yourself, Mr. Lockett. Sorry.
Okay, thank you so much, committee and Chairman Becker-Finn. To answer the question, I'm sorry, I'm working at the same time. To answer the question, the air ducts, this is a 1940s house, And for Representative Johnson, yes, I did get in contact with the City of Brooklyn Center. My landlord is on it. So I will give her kudos for that after I had to struggle for 2 years to get that done. But when the inspector came over from the City of Brooklyn Center, they came in, they have devices to measure the heat throughout the room. Now we control our heat because and then she installed a brand new furnace. But the culprit of the problem is the reason why the other rooms in the back are not getting the heat because one, the air ducts need to be vacuumed out. She refuses to do that. And the way that the heat and everything is set up, they have the pipes in the basement where it will cover every room in this 3-bedroom house. But the fact when she also installed the new furnace in, because they had to get a brand new furnace, the thing about it is that the new furnace do not push out enough. But the culprit of the problem is two things. Air ducts need to be cleaned. They have not been cleaned for years and vacuumed out. I even had a friend of mine that owns a company that would do that for her, but she refused to do it. And then the reason why we had to buy those furnaces and those space heaters is simply because we was not getting that heat. And you know, the Minnesota cold winters is very disrespectful. That's what I call it. So that's basically the reason why what's going on. But Representative Johnson, yes, I did step up. I did get in contact with the city inspectors, and they had so many repairs that they had to finish. She's working on those right now as we speak. But this bill right here would suffice for that. And that's the why I want to clarify that for the other term as well.
Yeah, thank you, Mr. Lockett. And I think it's important too that the bill itself, you know, the onus is on the landlords. They're the ones collecting the rent. You know, this isn't a bill about, you know, the extra steps that every single renter should have to take to fight for what's already in their contract. Representative Robbins, your final question.
Thank you, Madam Chair. So if someone could address, like, when it's 36 inches from a wall, what that actually means in practice. And secondly, if they're allowed to be on these energy conservation heating plans or not. And then my last question was about, you know, the situation in Texas. There doesn't seem to be any allowance for a force majeure situation where there is like a regional disaster from either the grid going down or a weather event. So just if you would consider, you know, speaking to that. Thank you.
And I think Mr. Spade, one of the other testifiers, had his hand up. So Mr. Spade, I'll go to you for a response.
Thank you. Again, this is Samuel Spade. The first thing I want to repeat, which I know a couple people have said, is that not only is this the tenant's home, but they're actually paying money to live there. They're not there for free. They're paying money. They're buying a service from the landlords, and landlords are obligated to provide the service that they promise. And especially with emergency issues and heat, it's not about intent of the landlord or bad intentions, or even whether the landlord caused the repair issue. Obviously, landlords are virtually never causing the repair issue. It's always something else that is happening. The question is about who has the obligation to fix it. And again, that is what the landlord, bluntly, is being paid to do, is to keep the property maintained, among other things, of course. And to answer the question then about the 68 degrees in the rooms, I mean, if it were a tenant who had called us and they were saying, how do I measure the temperature? I would probably say, you know, you stand in the center of the room with a thermometer, make sure, you know, if you have to, you get a yardstick out or a measuring tape and you're far enough away from any wall or window. Again, the thing being, if, you know, you stand next to an outdoor window in Minnesota and you put your hand next to it, it's obviously going to be a lot colder than if you're, you know, in the center of the room or something like that. Again, floors also generally much colder. So the idea is to get an accurate temperature. And then to address the idea of different rooms or, you know, catastrophic things where there are losses of heat and maybe you cannot fix it for a period of time. You know, there are situations like that, but the law also covers it. In many cases, what would happen is the tenant would be due some amount of rent abatement, again, because they aren't getting what they were supposed to get during that time. And there's no blame there or moral judgment on anyone. It's just that if a tenant is paying for something and they are not getting what they're paying for, then they are refunded some portion of it. So in the event that there was a catastrophic thing, like what happened in Texas, and the heat went down, say, to 50 or lower, the tenant had to go to a hotel, that would generally be compensated for in other ways.
All right, thank you, Mr. Spade. And we're going to move on to Representative Liebling.
Well, thank you, Madam Chair. And I just really wanted to thank Representative Hurd for bringing this. It's obviously a very difficult issue in a lot of ways. And she's obviously worked very hard to find something that's workable. I just wanted to comment that I just find some of the comments amazing. All this does is give landlords a right to go to court if some of these things happen. And, in the real world, if the power goes out for your city, a judge is not going to hold the landlord individually responsible. That's just not what this is about. This is not about saying, oh, the pipes all froze, you're going to be punished, you're a bad person, or anything like that. I think Mr. Spade just said that very well. And the other thing I just wanted to comment really quickly, one of the other testifiers gave an example before of a tenant in a multi-tenant building behaving inappropriately, opening the window or something. And I just want to say, in those situations, it's the landlord who has more control than that tenant. The other tenants are complete victims of that. It's not like all the tenants are ganging up and so they are all responsible for what one tenant may do. So it's really, as Mr. Spade was expressing, as I read the bill, it's just a matter of, who has more ability to impact this. If you're one tenant in that building and some other tenant is doing something, you have no ability to impact it. Where the landlord has more, maybe not complete, but they are the one who can hopefully do something about it. So I really appreciate this bill, Representative Hurd. I think it's really long overdue, and thank you so much for taking it on.
All right, thank you, members, for the discussion. We will move on. Oh, Representative Scott, and then we've got to end right at 10 o'clock. So keep it focused, Representative Scott.
Yeah, Madam Chair, thank you. And I just want to say, Representative Hurd, I understand what you're trying to do here, but not one of Representative Robbins' questions were answered, in my opinion, adequately. And so I would hope that maybe you would work on getting those answers. What happens if somebody is on an energy saving program? If we're trying to conserve energy and the heat is automatically going down, say in the evening or whatever, what happens in that situation under this bill? Anyway, I think there were a lot of questions there that weren't answered adequately. And so I would hope that the bill's author would find answers to those. Thank you, Madam Chair.
Yep, and maybe a good tip for everybody is if you have multiple questions, it may be helpful to ask those questions one at a time. I will go back to you to ask your second question, but I know it can be confusing when we're trying to fit 3 questions also as we're sharing our opinions at the same time. So a good reminder for all of us to make committee go more smoothly. With that, there are no amendments to House File 398. Representative Hurd renews her motion that House File 398 be recommended to be placed on the General Register. The clerk will take the roll.
Chair Becker-Finn.
Aye.
Representative Moeller.
Aye.
Representative Scott.
No.
Representative Feiss.
Aye.
Representative Frazier.
Aye.
Representative Grossell, excused. Representative Hurd.
Aye.
Representative Hollins.
Aye.
Representative Johnson. Representative Liebling.
Aye.
Representative Long.
Aye.
Representative Mortensen.
No.
Representative Novotny.
No.
Representative Farr.
No.
Representative Robbins.
No.
Representative Vang.
Aye.
Representative Zhang.
Aye.
And Representative Johnson.
No.
I have 10 ayes and 6 nays.
All right, with 10 ayes and 6 nays, the motion prevails and House File 398 is recommended to be placed on the General Register. We've taken it right up to 9:59. We will recess and come back at 5 p.m. today. I will just remind members that there is a different link for the 5 p.m. meeting. So if you click on the 8:30 a.m. Zoom link, you won't be able to join us. So just a reminder for members. And with that, we stand in recess.